I'd now like to hand over to my dear friend and colleague, Catherine Bastow, who was a local lawyer here for many, many years and taught me all about real estate. So, Cathy.
There are very few familiar faces in this crowd. I did leave 8 years ago after practicing in Port Hedland for 9 years, and my little office was up on Kingsmill. I'm now down in Mandurah, but you know, my children were born in this town, my husband was as well. And so I have this affinity, and this friend of mine made an opportunity for me to come up and speak to you tonight. I don't know that you're serviced very well in this area, and you know, it's a tedious topic, but today's theme is set pretty much with Port Hedland people specifically in mind, working hard and making the most of your wealth. And of course, from my point of view, I'm talking about making the most of your wealth for your people that you leave behind, for your estate, for your wife, your husband and your children. Well, you're all in Port Hedland, so you're already doing the first bit, you're already working hard. So I just wanted to go through a couple of nuts and bolts things just to give you a hand with your housekeeping. As you grow wealth, there isn't very much point in allowing that life work to simply go off to chance. And that's what will happen if you don't have a will or you don't have a good will. My sister-in-law today said she didn't need one. She was in a long-term de facto relationship, and she assumed that if she didn't have a will, it was simply going to go to the partner. And I don't think she's an unintelligent person, and I don't think that that's an uncommon misconception, but it's absolutely incorrect. And it may, and I'm going to give you a couple of scenarios which debunk that comfortable assumption. But there are three main ways that you can waste your money through your estate. The first one is you have no will at all, and there are two aspects to that. Is your loved ones may not receive, and the other one is the public trustee may. So that's the first one. The second one is if you make an irresponsible will, and probably everyone in here will be surprised to know that you can't just make any will you want. There are limits to what you can put in your will, and very specifically, who you can leave out. So there are real dangers in that. And the third one I want to talk to you about is doing it yourself and doing a will kit. There are practices of lawyers and barristers who make a very good living out of fixing up problems where people haven't put together a proper will or have not done the best job that could be done. The first one I'm going to go into in a bit more detail. The tagline is, where there's no will, there's no way. By which I mean, there's no way of guaranteeing people that you love will benefit. Invisibly, behind or in front of us or around us, is something called the Administration Act. It's a really ancient piece of legislation from 1903, and it sets out a matrix of where your stuff is going to go if you don't do a will. That's why we do wills, because we have to superimpose our wishes on the Administration Act. And it's there, no one knows it's there, and we have to study it so we know it's there. So if I go through one scenario, you may realise that these Administration Act rules actually affect you. The scenario is you and your wife have a house. It's worth $1,050,000. There's a reason for that funny figure. It's in husband's name. He had it before you got together, and you just left it in your name. Then you've got a couple of investment properties, and there's a bit of equity in each of them, maybe $100,000 in each. So the total assets are $1.25 million. The rules of intestacy provide, okay, and this guy, he dies, he leaves his wife and 2 children. The rule says she gets the first $50,000, because in 1903 that was a lot of money. But she gets the first $50,000, the chattel's in the home, and 1/3 of the balance. So following the maths, she's going to get $450,000, which means she won't be able to stay in the family home. She can make an application. She can engage some of my friends, the lawyers, who can come along and make an application to the Supreme Court that she can have the house. And subject to the Supreme Court judge's discretion, she may or may not. So we're looking at litigation in the tens of thousands of dollars in the Supreme Court. So there you go, that's the first one. And it actually happened in Port Hedland to a client of mine sufficiently long ago for nobody really to know the circumstances, but it was a situation where an older chap had married a younger woman. So he already owned a commercial property in a suburb where they were living in more or less a donga, and the young wife and he had a baby, and he died without the will. The public trustee said that she could go on living in the donga, but because the property was a commercial property, the income generated from the property was half hers and half the child's. Where there's only one child, it's shared half and half. There's a slight change in the rule there. So for the rest of her life, she had to pay her son half of the income from the units. Previously, her husband and her had survived on the whole income, which was now reduced to half because the money was paid to the public trustee who was looking after it for the son in due course, and he would receive it when he was 18. So that was a really terrible scenario. The second one, which is also a common one, is you leave just a wife. You're young guys, you've come up to Port Hedland, you're living in, say, here's accommodation, so you've bought a property and it's just an investment property. Now it's worth $1,075,000, another magic number. You've paid off most of it, you thought you'll have your children when you've paid off most of this investment property and you're established, and unfortunately something goes terribly wrong. You've got $875,000 worth of equity in the house. Good news is your wife gets the first 75, not the first 50, and there are no children. So she doesn't have to share with any children. If husband left a mum and dad, or not, and a brother or sister, or not, nieces and nephews, any of that class will share in half of what he left behind. So in that scenario, she'll get $475,000 and have to get a loan for $400,000 to pay out the balance of the beneficiaries. There is a good one. There's a good scenario. If your husband's already died, I'm sorry, I'm looking at you. I'm not looking at you. Already died, and you've got 2 or 3 children. That's a perfectly sound intestacy rule, and the kids will get it. So there is that one that you don't have to worry about. In all my scenarios, I've assumed that one person owned the property and it wasn't jointly owned. And by and large, married people will own property jointly. That drives me to a topic of that's important, that you understand what is in your will and what is not in your will. I cannot make a will that makes provision for a jointly owned property to be left to anybody. When you die, your spouse will inherit the jointly owned property. Outside of the will, there's no way. I've had a second time round people say, can't I leave my half to my children and she can leave her half to her children? No, can't. It happens by operation of law, and it sits right outside the will, as does your superannuation. Trustees of your superannuation fund are bound by the superannuation document and the deed to make sure that your superannuation entitlements are paid to your nominated beneficiaries and or dependents. And there's lots of rules around that. So most of you will have made your nomination in your superannuation fund as to who's to get it. And the young ones have left it to their mums, and the older ones will have left it to their wives. But just make sure, if you're on the second wife, that you've changed all of that route and you've caught up yourselves. All right. So look, there could be a scenario where you don't need a will. You may be married and all you've got is a jointly owned property and some superannuation, you've already done a nomination. You can rest assured while that estate remains static and in that form. All right, second form of waste, I call where there's a will, there's a relative. And that is the area of inheritance law. And that is that whole area of what freedom do you have as a will maker to leave people out. So you've got your classic situation where dad's died, mum's got everything, and she decides that Donnie just doesn't deserve any. He's been a good for nothing, she's tried her hardest, there's nothing but take drugs, his girlfriend's an alcoholic, and she doesn't want to leave her husband's hard-earned estate and their life work to the pair of them, essentially Donnie, the son. He's part of a class of people who can bring a claim. She exposes the whole estate to a big squabble between Donnie and his 3 siblings, for example. He may have fallen on hard times of his own fault, and she may have very good reason to ensure that the rest of it is not put up his arm or down his girlfriend's throat. But there's real dangers in that. And the dangers arise with when Donnie says he doesn't like it and he wants a share. He can bring a claim against the estate. The rest of the siblings will be held up in litigation. There'll be oodles of money coming out, and in a number of cases, out of the estate. And if Donnie is really down in the dumps and mum had a reasonable sized estate, I can tell you, odds are on he's going to get something. And now that's a whole topic that my good friend Rob Nash lectures us in, and we do it in our continuing legal education. It will take a whole afternoon to get through. But the upshot is you have to make a will that is responsible and makes proper provision for your dependents. Normally what we do is we pop some insurance in a will, and we say, we'll give Donnie, you know, who cares, $50,000 for the sake of argument. Just see if it's enough to keep him quiet, he's got something. So a lawyer needs to know sort of what the outcomes are likely to be and what sort of insurance we can put in. On one lady's will, we did a really, I was pretty proud, but we did a really clever thing. She had cancer and she was going to die, and she really didn't want to make provision for her daughter, her 6th child. But she wanted to make provision for 5 of the children. So what we did, she only owned a little house. We did a transfer of the home from her to her and her children in the 5 that she wanted, in 5 equal divisions. And each division was held by her jointly with one of the children. And as I said before, if something's held jointly, it will, by operation of law, just go to the survivor. So then, when she died, and we had some predictability about this, the property went 5 ways into 5 of her children, and it was out of the estate. It went by operation of law at the moment of her death, and it never went into her estate. And so it was beyond challenge. I only learnt that because I was on the opposite side of one of those to start with. So that's where there's a will, there's a relative. The third one is where there's a will, there's a lawyer. And this is where they make loads of money. I had a talk to Mr. Nash before I prepared for this talk, and he said 90% of his work comes from home-drawn wills. Now, he would probably like me to encourage you all to go down to the museum and get a will kit so that you can save $100 for each of you, do your own will, and then in time when you have got no knowing about what's going on, you can assist Mr. Nash in sending his 2 beautiful daughters to PLC. Because that is the kind of money that it takes to sort it out at that end. It's housekeeping, guys. It's just sensible housekeeping. And that's why it's a boring topic, because I know none of you guys in the room actually think you're going to die. And if you make a will, that's going to increase the likelihood. The lessons are, don't do your free wills with the trustee. They offer free wills, and then once you do a will with the trustee, they will take a percentage of your estate, about 4%. So that goes from the top. Then, imagine a government bureaucratic office trying to deal with stuff for you. Any interest in keeping the costs down? Any interest in doing it quickly or efficiently? I'll just leave that one out there. Don't do it. It's not a free will. It will never be free. Will kits, also false savings, because they're prone, well, they're feeding the lawyers already. Get qualified people to do your law, to do your will. And accountants are not qualified to do wills. I'm not, there are accountants who hold out that they can do them, and it's not right. I don't profess to give financial advice, and you need to get a lawyer to do this. We go to the seminars, we know all the stuff, and there's a lot of learning behind a summary like this. Review your will. You need to know that if you are married, you become married, or you divorce, I'm trying not to look at anyone in particular there, I'm scanning the room. If you get divorced, it will void your will. That might make some people uncomfortable. And if you have had a marriage or a divorce since you made your will, you don't have a will. Do your will before you lose testamentary capacity. You've all got it now, but one day it goes. That's all I've got to say on wills. 5 minutes on enduring powers, if I may. When you lose legal capacity, when your marbles roll out and under the couch, you don't care what happens to you. You have a smile on your face, you're down the street in your jammies, you left the stove on and the bath's running. What would you care? And that's what clients say to me. I don't need to do an enduring power of attorney, I'm fine. It's the reality. But it's not about you, it's about the people that you leave behind and the courtesy of leaving your affairs in order. There are a lot more decisions to be made when somebody loses capacity. When somebody dies, you put the notice in the paper, you have the funeral, you have the wake, and then you just have to get on with dealing with the emotional stuff. If someone loses capacity, an aneurysm, an accident, work, road, stroke, age-related dementias, but I'm really not talking to that kind of audience. I could do that in Mandurah quite happily, but I've got a different audience here. If in those circumstances, unpredictable as they are, you lose legal capacity. You thought you owned your house. You thought, well, that's always been my home. Well, Jan's not going to list it for sale if you decide that you want to move to Perth because you're closer to family support and medical support. Jan's going to say, well, it's in joint names. I need both signatures. Difficulty arises that you have to make an application to the Guardianship and Administration Board 6 to 8 weeks ahead at a time when you really just do not need it. Enduring powers of attorney are not my secondary topic. They are absolutely as important as wills. If you're going to listen to Paul Clitheroe, any of those people who know what they're talking about in terms of estate planning and putting your house in order, that is one thing that is mighty, mighty important. And it may not appear to be essential now, but it does need to be addressed at some time going forward. And I just need to plant the seed in all of your minds. There are other instruments that are now available, and I'm not going to talk now. I just need to tell you there is something called the Advanced Health Directive now. It's only been in place since February last year. It's a living will. People can now make a directive to their doctors to withhold treatment if they are unable to verbalise. That young man who was a quadriplegic, who won that really courageous battle in the Supreme Court to say, I don't want to live anymore and I don't want anybody force feeding me, I want to be allowed to die. He could do that after the case because he could verbalise it. But a doctor can't take instructions from somebody who's already unconscious. And that's where the Advanced Health Directive comes in. And in time, these documents will be held in a registry with the Health Department. And I think it will be a good thing to be able to make provision for clarity of instructions at a time that is going to be vital for the person concerned. There's another thing I'm not talking about tonight, and that is testamentary trusts. There's more complicated wills. The accountants and financial planners will refer you to lawyers who can draft those more complicated wills where, one, the threshold question of the size of the estate has been answered in such terms that it's quite sizable, so many people in this room will qualify, and there's a need to protect one of the beneficiaries of the estate. Alcoholism we've done, oddly enough here in Port Hedland. So we had to protect an alcoholic beneficiary, and then we have other protective ones. The farmers love these mechanisms to ensure their daughter-in-laws don't take a share of the farm. So it's to keep things in your bloodline and to keep the readies out. They're very complicated, they're a whole topic of their own, but please let me just impress upon you, there is a need to think about it and to get your house in order. We provide these services. We have a website and you can go into the wills section and fast track an appointment. There's a client sheet in there that fills out the details that you need. We have set prices. I do come up and we can do appointments in person. And if it's not done with me, just make sure you find somebody that you do trust and get it done. So that's all I want to say.